Good day to you. This week's tutorial is designed for managing agents, for owners and for trustees to highlight some of the provisions of the new Sectional Title Schemes Management Act number 8 of 2011, identifying what are perhaps major issues, that is, changes in regard to scheme management. For the purposes of this tutorial, I assume that you know the existing governance provisions in the existing Sectional Titles Act and that you've read this new act, which, if you haven't, is in the library under pending legislation. I've given you a heading which illustrates this issue. I was recently given a question thrown at me: what are the top 3 issues? And I stumbled through it, gave some answers, but at the end of the day I looked at this thing more carefully after that question and thought they're probably not just 3 issues, they're probably more. So just to give you an idea of where we're going to go in this video tutorial, I'm going to talk about some of the upfront advantages of this particular piece of legislation, but then I'll hone in on 8 issues: reserve funding, meetings, body corporate powers, certificates and records, fiduciary position of the trustees, administration in the sense of administration of a scheme, the chief ombuds role, and the role of provincial ombuds. So let's first look at the upfront advantages. All scheme management issues will be dealt with in one act. It is clearly written. It's much more modern language. The original act was drafted in the mid-80s. There's much less Latin for starters. There are fewer long multi-indented clauses. I think it is just an easier act to read altogether. It's better laid out. The bits of governance were scattered all around the existing Sectional Titles Act. Now they've been brought together and logically clustered, as it were. It is, of course, gender sensitive, and it's been checked for constitutionality. As with anything else, some people take to change. They adopt quickly. They dive in, get to know exactly what's going on. They see change as an opportunity to understand what is going to happen. Others, of course, are more reactive. They adapt. They will avoid the terms of this new act as long as possible because they see the change as a threat, and then they only learn the bits and pieces that they need to as and when they think that they can't do anything else. This tutorial, made before this act comes into operation, is for the early adopters, those who look forward and who make business judgments based on what is to come. Let's look at reserve funding. It's a major issue. There's always been an obligation to put aside money for contingent expenses, but it hasn't been real because it's always been tied to whatever the owners think is reasonable, and that, of course, is within their entire discretion. It's a value judgment. But now the Act is going to make that real. The Minister will set minimum reserve levels, and there will be instructions as to how you should calculate reserves. Those will be in the regulations. Will there be separate operational and reserve levies? Well, I'm not sure of that, but we'll find out. There'll certainly be separate operational and reserve funds that will have to be kept separate. And one of the questions that will be asked is, there's now going to be more money in the equation. Managing agents and trustees will be managing more money because there have to be amounts set aside for future expenses. Budgeting will be on an accrual basis. So more money in the equation, more risk of theft, I suppose. But at the same time, the ombuds will be asking for annual financial reports from every scheme, so there'll be more transparency in scheme administration, the finances in particular. Let's look at meetings. The new Act, you will notice, is much heavier on meetings than the Sectional Titles Act is. This really is more apparent than real, because what's happened is that bits and pieces that were relevant to meetings, which were embedded in the definition section, have now been taken out, and this new section 6, which I suggest you look at carefully, is I think a great improvement. It's much clearer on the requirements for sending documents, and those in fact have been changed. Now there isn't this question of deeming. You'll see it's much clearer as to how you send notice. The issue of electronic delivery hasn't actually been addressed as it should. It's been mentioned, but it hasn't been specifically addressed. I think that's something that perhaps will be dealt with in more detail in the regulations. There is a limitation of 2 proxies per person, and that's something which is going to be an issue that has to be dealt with. Again, the regulations may address what some people believe is going to be a problem in scheme management. I don't think it's going to be a problem. I think it's going to work out quite well in the end, and in the end we'll have a more democratic result. There will be one vote per member when votes are counted in number. That's been an issue since 2005, but that is now clear, and so we can get an understanding of what special resolutions mean in that particular context. The body corporate powers, again, these were somewhat scattered around. The new Section 4 is an adjusted version of the existing powers, as they more or less as they would have been in Section 38 of the existing Sectional Titles Act, and Section 5 is a whole lot of additional powers. They're not brand new, they are really just a compilation and a concentration of all the additional powers. You'll find in 5 everything to do with anything that results in the deeds registry. So it's all the registration issues are concentrated in 5, whereas the ordinary management issues are dealt with in 4. The body corporate general powers in 4 are adjusted, and special resolutions are now required when a body corporate buys or sells or leases a unit. You know, there's still the requirement that that be necessary for the purposes of administration of the scheme. There's also a special resolution required for borrowing money, which I think makes sense, and for letting parts of the common property to owners. Let's look at certificates and records. A bit more detail on that. There's an obligation on the body corporate to keep proper copies of the rules. You know, thus far, sometimes body corporates have just had a certificate by a conveyancer saying the standard rules apply. That doesn't tell you what the standard rules are or how they change over time. So those rules are going to have to be kept. They're going to have to be kept available. And as people change, as the occupants of sections in a scheme change, the body corporate is going to have an obligation to give new occupiers copies of those rules. Which I believe is sensible. There's also going to be an obligation on a body corporate to advise owners what of levies once a year. Of course, that's an existing obligation, but annually and then every time a levy changes, and that you will see. Have a look at this, because you will also see that the certificate requires that exactly how much is outstanding also be certified. So more transparency in that regard. Fiduciary position of trustees. The Chief State Law Advisor took the existing provision in this regard and just reworked the entire thing so that it's clearer, but there are some subtle changes involved in that. Again, this is an issue that will probably be supplemented in the regulations that come out under this Act. If we look at the issue of administration, when a scheme is being helped out of a difficult administrative or financial mess, this has been completely revamped. Instead of having to go to the High Court, magistrates will now appoint and remove administrators, and the administrators will have to hold meetings, have to keep minutes and that sort of thing, and they will be reporting or sending through reports of the scheme documentation through to the Ombud at least every 3 months. So the issue of schemes being under administration for a very long period and there being no feedback is not going to happen anymore at all. So that's a completely new take on the question of administration. The role of the Chief Ombud, who will probably sit up in Pretoria or Midrand or somewhere, is a centralized a position, and the body corporate has an obligation to advise the Chief Ombud of its service address. Either an owner or a body corporate can approach the Chief Ombud for a special or unanimous resolution when they can't get one. The Chief Ombud approves rule changes, approves the original rules that the developer puts in, and then approves all changes that the body corporate makes by special or unanimous resolution to those rules. So those rules will be examined now, as they were prior to 1997, and the Chief Ombud will keep records of scheme rules. And the Chief Ombud also is the chairperson of the Advisory Council, which will advise the Minister in regard to the regulations and changes to the Act from time to time. And then the position of the individual ombuds, which we expect to be at provincial level. One of the things introduced by Parliament was that you can take ordinary levy collections to an ombud. I think that's going to be a big change. The Ombud also is the person or an adjudicator appointed by the Ombud would be the person who determines whether opposition to a use change, an intended use change, is fair or not. Before that had to go to the magistrate's court. Now that will go to the Ombud's office. The administrator's reports and copies of scheme administration documents will probably come through the local ombuds before they go up to the chief ombud, and the ombud also, if there is any lack of agreement, any dispute as to how compensation monies for expropriation should be shared amongst owners, then the ombuds adjudicator would make a decision in that regard. This is just my initial list of things. You may think that certain other things are more important, and I will in due course do a much more scientific analysis of the exact changes between the current legislation and the new legislation. But just this, as it were, off the top of my head, these are the 8 things I think are probably most significant and that you should start thinking about at this stage. Thank you for watching this Paddocks Club tutorial, and I hope to hear from you in the discussion forum on this and other issues.